People v. Morgan.
May it please the court, may I reserve 3 minutes?
Yes.
County Court did not hold a sufficient hearing under 67010 to warrant the introduction of prior testimony of a witness from the first trial. This case, a week before trial happened, the people made a request, in order to show cause, to get into evidence very important testimony that happened at the first trial because a witness was unavailable. At the time, the defense specifically requested that a hearing be held and that testimony be allowed, that the defense was not going to accept the very brief letter submitted by the people at face value, and requested that a hearing be held. County Court ultimately decided, after going back into chambers and reviewing, statute came out and said that this was a sufficient hearing and permitted the testimony. What I want to draw...
So what is the problem with relying on the letter?
The problem with relying on the letter is it essentially is a violation of due process, which is what the statute is designed to do to protect a defendant's right to confrontation. Drawing a parallel to...
So you get a witness. You always get a witness if you want one.
No, not always. So the parallel that I would like to draw the court's attention to is where a hearing is conducted when there's alleged misconduct on the part of a defendant. This court in People v. Johnson, it's not in my brief, it's 93 NY 2D 254, discusses when a hearing is required and when a hearing is not required under those circumstances. The hearing is not required when the evidence overwhelmingly establishes misconduct on the part of the defendant, or in the instance of waiver, for instance. And so what this court has done has drawn up a specific circumstance where there may not need to be a hearing. So it seems to me that this is essentially the same thing. There's a slight difference, right? There's at least some opportunity for cross-examination or opportunity for cross-examination under 67010 as opposed to misconduct by a defendant, potentially. That's really the only distinction there. So this court has held that a hearing is absolutely required with those exceptions. I think that that same rule should be applicable to 67010.
So if the letter had instead been a sworn affidavit from the doctor, that still wouldn't be sufficient? You'd need to have a hearing and bring the doctor in?
I guess it's twofold, right? One is I think a sworn affidavit from a doctor could be sufficient, depending on also what is relayed in that affidavit.
Well, suppose it has the same content as the letter.
Then no, I don't think that the content in there, particularly with it was a very brief letter. And what happened was when the court came back and made its ruling that this was a sufficient hearing, the defense placed on the record that there were alternatives that wanted to be explored, which is why the hearing was required. One is virtual testimony. That letter basically just said it's not recommended she testify. It could be stressful.
But even with a virtual hearing, does that not require testimony and potentially, albeit not in the courtroom, still putting a person in the situation that the doctor advised against?
The problem is that letter is so I guess the question is if the rule is if one doctor says it's not recommended that somebody testify because of whatever condition that they have, and that needs to go and put that in a letter and that is plainly sufficient, then obviously I'm not going to be successful in this argument. The question really is what...
Doesn't it depend on who that doctor is and their relationship to that particular witness?
Yes, depends on who the doctor is. And the other thing that...
And the reasons they give for why the person can't testify.
Correct.
But if those are the types of things the judge is looking at, and that judge is in the courtroom, and what standard are we reviewing that judge's decision under?
I don't think it's an abuse of discretion standard. I think it would be the same standard applicable for a hearing in context of misconduct by a defendant, which is not an abuse of discretion. It's a de novo review of what the court did. So in this case, all that was said, and the problem with not having this hearing, right, is one, the reason why a hearing is had is, on the one hand, make sure that no gamesmanship is going on, right? How is a defense, unless you're going to waive it, you don't care, it's fine, we're going to allow the testimony in, how is the defense going to check up on the validity of this letter?
What would you have, how did you imagine the hearing, who would be the witnesses of the hearing?
The witness at the hearing would be, certainly it would be the people's burden, right? It's their burden to establish unavailability. So they would, I would imagine, call the attending physician, some sort of doctor. And I would imagine that would probably be the only witness. And the availability of the hearing, you're then able to ask the doctor, very specifically, whether reasonable accommodations can be made. One is the virtual testimony. We don't know, this record certainly doesn't establish whether or not the doctor's concern was travel from Virginia to New York, whether testimony in court as opposed to from a hospital bed would be more stressful under those circumstances. Those are all things that, could be addressed and should be addressed at the type of a hearing. And unfortunately, the court did not do that. The other issue in the dissent to address is the Batson issue.
I'm sorry, before we leave that just for 1 minute, did you preserve a constitutional confrontation clause claim here or just a statutory claim?
Well, certainly I did not use the words, confrontation clause during the conversation with the court on that. My issue with that analysis is the reason why 67010 exists is it is a legislatively authorized and judicially approved way of circumventing a defendant's right of confrontation. And my argument at the time was essentially you're not following the statute, not holding a hearing, which is depriving my client of the right of cross-examination of this witness. We did challenge, I believe I did make very specific reference to the fact that the cross-examination at the first trial was insufficient, and I understand the case law on that, but it becomes difficult in these contexts where you now have a retrial, where the issues are very different than what happened in the first trial.
So the confrontation claim, seems, goes to the original witness, right? Not the witness you would have called at the hearing.
Correct. Yes. The defense, during jury selection, made a Batson challenge.
Can I ask you on the Batson over here, on the Batson issue, is it your position that a court can never make an implicit determination on step 3, or just that whatever happened here was not sufficient?
I think that a court can make an implicit determination depending on what the defense arguments are.
So why not sufficient here, would you say, if it can be done that way?
So I believe it can be done. There's certainly case law that supports it. I understand the principles behind it as well. But if the prosecutor states race-neutral reasons, in their opinion, what are race-neutral reasons are on the record, and the defense is then given an opportunity, as they're required to do so under Batson, to rebut those, race-neutral reasons, and they simply say nothing further or something like that. And the court just denies the challenge at that point. I think at that point you have, from there, an implicit decision by the county court, and basically almost a concession when the defense attorney does not actually challenge the prosecutor's reasons.
So what about, it looks to me that at the close of the colloquy, basically, the court says, I believe it's the prosecutor, Mr. Carty, was that the prosecutor?
Yes.
Okay. I just want to make sure the record is clear. Any dispute, and there was no response from defense counsel, judge, and I take it was you. You respond, no judge, no dispute. So why doesn't that bring any question about the Batson issues to a close?
Because that was not in relation to the Batson issue. The court makes its Batson determination and then talks about the remaining peremptory challenges and who is to remain to be seated, and then asks whether there's any dispute. And that is when Mr. Carty says, no, I don't respond, and Mr. Carty follows up with making sure that that's correct. It certainly did not have anything to do with the Batson.
Can I ask you then, can I ask you then about the exchange between the court and defense counsel and the ultimate decision, because it does strike me that is an implicit determination as step 3. So let's see what your response is. I mean, defense counsel is making very clear that the argument is that the court should not credit the reasons given by the prosecutor for the two remaining, right?
Yes.
Those two. But the court clarifies, what about the third one? And then counsel says, I am agreeing that he being the prosecutor, provide a race-neutral reason that I find to be credible. So it is obvious throughout this exchange that, and there's an earlier part of the exchange I think supports this, but certainly here because it's closest to the determination by the court, that counsel is making very clear that there is a credibility part of this Batson determination and is arguing quite vigorously that the court should not credit. In fact, is suggesting why it sounds unbelievable. And then the court says, thank you with respect to the other two, right, because you conceded on one. I believe there's a race-neutral reason granted, race-neutral reason, which would permit a challenge or peremptory, which would permit a challenge or peremptory challenge by the people not subject to Batson, challenge granted. Why, in addition to what counsel is arguing there about the crediting the prosecutor's reason, why isn't this last part of it? Would permit a race-neutral reason which would permit a challenge or peremptory challenge by the people not subject to Batson. Not, the court is very aware of what it has to do under Batson and says, this is not a problem under Batson?
I see my time's up. Can I?
Oh, I'm sorry.
Please answer, yes.
I took all your time, my apologies.
So it's, I mean, first of all, the reality is you can always, say that just by the mere denial of a Batson challenge, that is the court implicitly making a credibility determination. And that's part of the problem is what the law says, this court says in Payne, is that it's the trial court's responsibility to make sure there's an adequate record to review and to develop. When you look at what county court said, it's not clear that county court's even referring to a reason that was given by the prosecutor. It's left open and saying, it didn't say the prosecutor provided a race-neutral reason that permits, it just says the court sees a race-neutral reason. You could construe that as the court finding its own reason, you can construe that as the court agreeing with one of the prosecutor's reasons. The record's certainly unclear on that point.
What is it that you said at step 3 to demonstrate that the reasons given were pretextual? Beyond credibility.
Beyond credibility.
Yeah.
Certainly, in terms of the length of residency, what was said is that that was just a bare bones pretext. I did not go into the specific.
But that seems like credibility, right? They're saying it's a residency requirement, but you shouldn't believe that.
I mean, that's kind of the nature of what a pretext is, right?
Well,
They're
no, I
giving-
mean, ordinarily what you see in a lot of these cases is somebody will say, look, there were 2 white jurors who were residents for only a year or 2, and the prosecutor didn't strike them.
Yep.
And that, you see that a lot.
Sure. So this was the first round of jury selection. The length of residency came from jury questionnaires that were filled out. And so in the moment in time when you're making these arguments, you don't really have the time to shift through the 30 juror questionnaires and do that sort of calculation on the fly. And so what was said was really credibility. And, I believed in arguing that it was a pretext was that there's no cause to tie this to this particular case. 2 years was insufficient for one juror, 5 years of residency was insufficient for another juror. How many years do you need of residency to, be considered an acceptable juror in that prosecutor's view? Thank you.
May it please the court, Chris Liberati Conant for the people. Your Honors, defense has a preservation issue with respect to both of the arguments he raised here today. To start with Batson, defendant failed to raise a specific challenge to the form of the Batson inquiry. And this court's law is clear. I point the court to both People v. James and People v. Smokum. The defendant has
What are you saying the defendant should have done that was not done with respect to the Batson?
Yes, it would have been quite simple here, Your Honor. He could have simply said, when the judge made the ruling that you read here today, he would have said, Your Honor, you did not rule on pretext. Objection. And at that point, the judge would have been able to clarify the record and address the problem right there. And I posit that the reason that
Well, so is it your view the judge didn't rule on pretext?
the judge absolutely did rule on pretext, but
Is that an implicit ruling? or explicit ruling?
So I just want to be clear, my first argument is this argument is wholly unpreserved, and so we don't need to
You made
reach
that
the
point.
issue. The second, though, is that, first of all, the judge did, whether you call it explicit or implicit, it is as close to explicit
Well,
as you
where
can get.
exactly is the explicit ruling? Where in the transcript?
It was in the portion that Judge Rivera here read today, and I understand the judge did not say you have not shown pretext, and so I will fall back and say that the judge got as close to being explicit as humanly possible without doing so. And I do emphasize
Well,
that-
aren't you really talking out of both sides of your mouth? Because you're saying to the defendant that he should have been more explicit and say, objection, you didn't do step 3, but you're not requiring that of the judge to say, okay, I'm going to rule now on step 3.
No, Your Honor, because preservation is a rule of this court that determines what the court can and can't review.
But with respect to the 3 steps of Batson, isn't that something that the court is supposed to do? And that's the court's responsibility. Are you not now suggesting that somehow it is incumbent upon the defendant to tell the judge, you didn't do step 3?
Well, that is what preservation is, Your Honor, is that...
I understand what preservation is, but with respect to the Batson steps that are required, is it true that there are, in fact, 3 separate and distinct steps?
Yes, the people do not
Okay.
contend that there are not, and the people do not contend that the judge needs to go through all 3 steps. But the people also contend that the defendant or the party opposing the Batson challenge has a responsibility to object and to object specifically to the form of the Batson challenge, and he failed to do so here.
Well,
And to-
he says, I think these are examples of pretext by the DA's office, and I think that my Batson challenge should be sustained.
Well, so that goes to a different issue, Your Honor, which is whether the people presented a race-neutral reason and whether defendant actually met his burden of showing that the people's reasons were pretextual. And that would be an issue that is essentially an affirmed finding of fact before this court. The court implicitly found that the prosecutor's proffered race-neutral reasons were not pretextual. And I do note, as the court has already noted here today, that the defendant at that time did not offer anything beyond conclusory assertions that the people's proffered reasons were pretextual, such as that other jurors had been excluded or had not been excluded even though they had lived in the county for, some number of years.
And is there anywhere in the record such discussion of other jurors and their residency?
I don't recall off the top of my head, Your Honor.
But
I
if it
not-
was incumbent upon the defense to assert same, is what you're arguing?
Well, the argument is that the defendant here did not offer anything aside from his assertion that I believe this is
Right,
pretextual.
but you're saying it's more than an assertion, it's an identification of the practice actually occurring in the manner that he suggests.
I'm sorry, I don't understand your question.
He can't just simply assert it in a conclusory way. You're saying the record needs to support the claim.
Yes. Well, that is largely correct, and he did, I do grant that he did challenge the credibility of the prosecutor in making that assertion, and the prosecutor was therein viewed by the trial judge, who was in the best position to judge the prosecutor's credibility.
So when you say, in response to an earlier question, that if it's not express, the judge's determination of the Batson challenge, if it's not express, it's as close as it gets. So what makes it close? Is it the language that I quoted that the court said at the very end? Is it the context? Is it both? What is it?
Well, I appreciate, Judge, that you made a point beyond the one that I made in my brief, which is that the context of that conversation is important, and the context of that colloquy is important. The judge made that ruling, as you just suggested to counsel, in direct response to his arguments that the prosecution's proffered reasons were not credible. So at the very least, by then listening to those arguments and saying essentially, no, this is proper under Batson, the people's challenge is proper under Batson, I'm granting the challenges, the court has thereby absolutely implicitly made a credibility determination, implicitly found that the people's proffered reasons are not pretextual.
Okay, let's say the court didn't find that so persuasive, but what about what the court actually said as is its determination?
Right, and so I don't recall the exact language, Your Honor, but I know you did just read it, and I,
Yes, thank you. I mean, no, I'm saying what, when you said it's as close as it comes, and you've
Yes.
already said I raised something that was not in the brief, so in terms of what you have argued to the court, what makes it as close as it comes?
well, both the passage that Your Honor read,
I see.
in which the court says that, you know, that the people's challenge is proper under Batson, and also the courts having just heard an argument on credibility and then rejecting that argument in granting the peremptory challenges.
How do you characterize the use of race neutral in a passage where you would expect to see the word pretextual? So going back to that very same passage you were just talking to Judge Rivera about, the judge keeps saying there's a race neutral, granted race neutral reason which would permit a challenge or a peremptory challenge by the people not subject to Batson, challenge prevented. I would have expected at that point, because you know, the arguments had already been made as to why they were pretextual, to see the word pretextual.
I grant that the court appears to have misspoken at that time.
That's
and
it,
used
they
the
just said the wrong thing.
language. And the case law cited in our brief stands for the proposition that when we're talking about an implicit ruling on pretext, the fact that the court happened to use the wrong language is not dispositive.
So how do we know then that he has made an implicit ruling?
Well, this is why preservation is so incredibly important here. Had there been a timely objection, the court could have ruled, could have
I'm not sure
clarified.
that's responsive to the question, though. If he made an implicit determination, how do we know that?
Well, so I think some of the very good evidence of that is he implicitly ruled that the people's reason, the people's proffered reason was credible because he ruled so immediately after defense counsel argued that the people's reasons were not credible.
So are you saying that is an implicit ruling on step 3?
I am.
Okay, and so if we should take that as an implicit ruling on step 3, then how is it that it's not preserved? I'm struggling, I don't understand how you could have both of those, both argue that it is not preserved and there's an implicit finding. It seems to me it must be one or the other.
Because he is bringing this argument here today that the judge at that time,
But you're saying, I think, that he put it before the judge sufficiently to get an implicit ruling on the question, yes?
yes, and what I'm saying, Your Honor, is if he believed, counsel believed at that time, as opposed to believing as he likely, as the people posit he likely did, he likely understood at that time that the court had just ruled on the credibility of the witness. And so failing to preserve that objection at that time actually prevented the court, prevented a proper record in this case. And so the defendant should not be allowed to sit on an objection like that, leave the record as it is, and then use it at the appellate level to then bring it up for the first time.
Counsel, do you just want to comment on the other issue on the hearing, specifically on how should we review the judge's determination?
Yes, Your Honor. So this again, counsel today raised unpreserved constitutional issues with respect to confrontation, with respect to due process. Today
On the
here,
hearing issue that is preserved,
excuse me?
on the issue that he
Yes,
did preserve.
there's no doubt that the issue of whether the statute was followed is preserved.
How do we, under what standard do we review the trial court's decision?
This is an abuse of discretion standard, Your Honor.
What about the point that this is more like misconduct by the defendant?
Well, I do want to note for the court that this is the first time that I'm hearing that argument, and so it makes it difficult for the people to respond when I have not had an opportunity to review it or research it. So again, this goes to the very preservation of
Then why do
issues
you,
by defendant.
try it the other way then, why do you think this is an abuse of discretion standard?
Because it is essentially, it's an evidentiary ruling. And so whether or not to admit the unavailable witness's testimony is an evidentiary ruling, and that's why it is an abuse of discretion standard. I do want to note, Your Honor, that 67020 of the CPL requires first that the people make a motion supported by facts. They did that here with the letter provided by Dr. Sangha. The statute then further requires that the defendant have an opportunity to be heard. Defendant manifestly did have an opportunity to be heard here. He did make argument. He did argue, in fact, that the court should hold a further evidentiary hearing, but as the appellate division held, this statute does not require an evidentiary hearing on its face. If the legislature had wished to compel an evidentiary hearing, it could have stated that an evidentiary hearing is required under the circumstances. And beyond that, too, even if there were error here, this would be harmless error, because this testimony, the testimony offered by this witness was corroborated in multiple other instances, including by the defendant himself to more than one person in his admissions to police, and including being corroborated by the defendant's brother. So the fact of this jealous argument that arose out of the defendant's belief that his wife had cheated on him was not dependent solely on the testimony of Ms. Trella. It was corroborated in multiple other instances as well. Your Honor, I also want to add, with respect to the issue of confrontation with respect to Ms. Trella, there is no, as Your Honor suggested, there is no confrontation issue here. The defendant had a full and a fair opportunity to cross-examine Ms. Trella at the first trial, and in his papers, Mr. Sharp has focused on what he would have done differently strategically, as opposed to any way in which the prior counsel's cross-examination of the witness was limited in that first trial. Your Honor, to move to the issue of the defendant's statements, just to briefly say, Your Honor, that the trial court properly applied the law of the case here.
I have a question on that. There was a suppression hearing in the original proceedings before the first trial. The defendant had this letter claiming to representation of the defendant at that time?
I don't know. That's presumptively the defendant had that letter at that time. I can't tell the court one way or the other whether he did or not, and that's one of the problems with the supposition that this letter provides an extraordinary evidence or an extraordinary reason to go beyond the law of the case doctrine. There's no reason to believe this is newly discovered evidence. This is evidence that defense counsel would have liked prior counsel to have used.
It seems to me this is more an issue for us of whether the judge erred in not reopening the suppression hearing, at least for this issue, right? I mean, we never ruled on the original suppression motion, right?
Well, that's correct, and there's a problem with preservation here as well, because the time for defendant to raise that to the appellate division first would have been on the first appeal.
But he didn't raise suppression on the first appeal?
I don't believe so, and I note that it's defendant's burden to show preservation, or it's the party making the argument's burden to show preservation.
But he made the argument in the trial court, right? And isn't our preservation rule really related to the trial court, not the appellate division?
But in this case, it should be related to the original trial court when he first had the opportunity.
I understand that argument.
However, irrespective of that, the law of the case was properly applied by the trial court here. I see my time is up, and so I thank your honors.
Thank you.
Counsel, can you just clear up this last issue if you know? Did the defense have the letter at before the first suppression hearing?
I do not know. And one of the issues first of all, I completely disagree that it should be preserved at the appellate division on the first instance. But the defendant did file a very voluminous 440 motion.
You never argued the letter in the first suppression motion.
Correct. The defendant did file a lengthy 440 motion that was denied by the trial court. The appellate alleging ineffective assistance on a lot of grounds. The appellate division never touched it because it was a very easy issue for them to reverse on. And so that's where the importance came into, bringing this letter to the court's attention and saying, we need to reopen this hearing, and that's why it should have been
But you
reopened.
never claimed you didn't have it the first.
I did not know the answer to that. The attorney who had represented him would not contact me back. I was about, I think, the 7th or 8th attorney reassigned to this client, so the status of the file was bereft. In terms of preservation on the Batson issue, the people can always say, you need to do more. The reality and purpose of preservation is to alert the trial court to the issue. Is there any doubt that that wasn't done in this case? in
Well,
terms of-
alerted the court that there was a Batson challenge. I think his argument was, did you alert the court that they had missed step 3? Because that's true. If you had raised that, the court could have said, oh, yes, I credit the reason given. I thought I said that, or whatever the judge might have said.
I squarely put before the court credibility as an issue, and the people would want me to, after the judge issues his ruling, continue to argue further. I think that sufficiently put the court on notice that it should make a credibility determination, and then the court did not make certainly any explicit credibility determination. And Judge Troutman, I just want to respond to the question about any other jurors in terms of length of residency. That's certainly one way of demonstrating a pretext. The problem is we're dealing with a small, largely rural county in Columbia County, where frankly most jurors are going to be long residing residents. And in terms of arguing a pretext other than credibility, as Judge Wilson asked me, is you're looking at 2 years, okay. It certainly doesn't seem like it. What's the relation to the case, right? How are you relating that to the case? And then there's 5 years on the other one. And then after the 5 years, there was another reason given that I think is completely not borne out in the record. And it becomes a point in time where, well, how many years is required to do so? And when you're talking about small communities and you're talking about minority representation in jurors, certainly some minority representation in rural counties are going to be people that move from different jurisdictions at a certain point in time. And ultimately, that's what was happening, and frankly, I think is why a pretext was established.
So
That
you
seems
arguing?
like- I'm sorry, that seems like something that you might have said at step 3. That is, Your Honor, this is a rural county. The incumbent population here is largely white. However, in the last several years, there's been an influx of other people moving in, and that's why this is pretextual. That would have at least been something.
Yeah.
I mean, hindsight is always 20/20.
I can
know.
always do more, yes. And, I think that, of course, when you're making arguments to a judge, you're also relying on the fact that this is a judge that presides in that county and lives in that county and is aware of those characteristics, without going into too much further detail. But certainly the record did establish that that juror did relocate from Texas to New York City and then to Columbia County. He did indicate to that.
But again, the
fact.
problem is when the case is on appeal, it leaves that county. On a case yesterday, I mentioned something from the community that I come from. I asked a question that my colleagues wouldn't necessarily know, but if you put it in the record, then you give the reviewing court more information, helpful information, let me say.
Sure, I understand. Only just my word, too, in terms of making an argument, but yes, thank you.
Thank you.